Hello everyone, welcome back to our channel Law Point. This is Renu Thomas, your host. Our previous sessions were on the topic Contempt of Court. Today, in this episode, we are dealing with the frequently asked questions on this topic. We have with us our Supreme Court of India's advocate on record, Mrs. Praseena Elizabeth Joseph, to answer the queries. Here comes our first question. Can judges be guilty of contempt of court?
Under Section 16 of the Contempt of Courts Act, judge, magistrate can also be liable for contempt of court of their own court or of any other court, similar to how other individuals are liable for contempt of court. An example to this is contempt proceedings initiated against Justice Karnan, who was a Madras High Court judge, later transferred to Calcutta High Court, who scandalized many judges and accused them of corruption without providing any evidence regarding the same. The Honorable Supreme Court convicted Justice Karnan for contempt of court and punished him with sentence of imprisonment for a period of 6 months. Here it is important to note that contempt means it is lowering the dignity and authority of court or interfering with the administration of justice, and it has nothing to do with the judge in his individual capacity.
Our second question. Whether contempt of court is against the citizen's right to freedom of speech and expression guaranteed under the Indian Constitution?
The freedom of speech and expression is guaranteed under Article 19, Clause 1, Clause A of Indian Constitution. To express one's opinion or constructive criticism on a public issue are important ingredients of development of democracy. However, this freedom of speech and expression is allowed so long as it does not violate another person's right, because this freedom of speech and expression guaranteed under the Indian Constitution is not absolute, and Constitution has placed reasonable restrictions to this freedom of speech and expression under Article 19, Clause 2 of the Indian Constitution. For example, if your speech is immoral or indecent, then you cannot say that it is your right. Or, while exercising your free speech, if you are defaming someone in public, then that is also not permitted. Likewise, if your speech is lowering the dignity and authority of court, then that is also not permissible under the Indian Constitution. Constructive criticism or a valid disagreement on a judgment is different from blatant attack on the judiciary, which could turn out to be a contempt.
The third. Whether punishment of sentence of imprisonment is same to both civil and criminal contempt of court?
Section 12 of the Contempt of Courts Act prescribes punishment for contempt of court as 6 months imprisonment or with fine of Rs 2000 or both fine of Rs 2000 and imprisonment of 6 months. Here, punishment for civil and criminal contempt are one and the same. However, the nature of imprisonment for civil and criminal contempt are different. In civil contempt, the prisoner is taken to civil prison where he is allowed to have his private clothing, bedding, food, other personal necessities, and civil prisoners are segregated from criminal offenders. They are allowed visitors during visiting hours, etc. In criminal contempt, the offender is taken to jail where all the restrictions are followed.
Our final question. What are the permissible ways in which Supreme Court and High Court can initiate contempt proceedings?
There are 3 ways in which the Honorable High Court and Honorable Supreme Court of India can initiate contempt proceedings. The first way is the court on its own motion or suo motu can initiate criminal or civil contempt proceedings against any person based on any news item reported in TV or newspaper. If a private person needs to initiate criminal contempt proceedings against a private person, then he must require the consent of the Attorney General of India before initiating the criminal contempt proceedings if it has to be filed before the Honorable Supreme Court of India. And if the person needs to initiate criminal contempt proceedings before any high court, then the consent of the Advocate General of that particular High Court is required while filing the contempt proceedings. Thirdly, in case of civil contempt, the party to the litigation can initiate contempt proceedings before the Honorable Supreme Court or before the High Court for flouting the order of that particular court by the other party to the litigation. These are the different ways in which the parties can initiate contempt proceedings before the Honorable Supreme Court or before the Honorable High Court of State.
Thank you for watching. Meet you in the next episode with another legal topic next week. Till then, see you.